dictated by necessity impairs that sacred reverence, which ought to be maintained in the breast of rulers towards the Constitution of a country, and forms a precedent for other breaches where the same plea of necessity does not exist at all, or is less urgent and palpable. Publius. And it teaches us, in addition to the rest, how unequal parchment provisions are to struggle with public necessity. You know, I mean, you start reading. You gotta read. Don't sit there like a bump on a log. Read. Get all kind of good stuff going here. I could sit here and read this to you all night. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in Constitution or laws of any state to the contrary is notwithstanding. The indiscreet zeal of the adversaries to the Constitution has betrayed them into an attack on this part of it, as also without which it would have been evidently and radically defective. To be fully sensible of this, we need only suppose for a moment that the supremacy of the state's constitution had been left complete with a saving clause in their favor. In the first place, as these constitutions invest the state legislature with absolute sovereignty in all cases not excepted but the existing Articles of Confederation, all the authorities contained in the proposed constitution. Remember I told you about how they tied them together? So far as they exceed those enumerated in the Confederation, would have been annulled. See that? And the new Congress would have been reduced to the same impotent condition with their predecessors. I mean, these people were wise way beyond their years. And this talks about the militia. They never wanted to have a standing army. Never. They always wanted the people to defend by a militia. They wanted the militia to be there ready to kick tail if there needed to be. They wanted to have a Paul Revere running down yelling, "The British are coming, the British are coming," or whoever. Somebody. They called them Minutemen. They call them Minutemen for a reason, because they wanted you to grab your kit and be out on the road in a minute, ready to kick tail and repel all borders. That's the way our forefathers thought. Now, they were wise men who had come from a tyrannical environment in the European marketplaces. They knew exactly what was going on, and they weren't screwing around. And the bottom line is they were deadly serious, and they were ready to sign their life. They pledged their life, their future, their fortunes, and everything so that we could have this Constitution. And I think we kind of owe them a debt, because a lot of them died miserably as paupers because they dared to sign the Declaration of Independence, and the king went after them with a vengeance. Do you understand? Now the bottom line here is we got a duty, and we're going to finish this thing up. We want to do some stuff on taxes, and then we're gonna be out of here. We're going to do two things on taxes. One is going to be on Title 31 United States Code Section 742, and we're going to rattle it off. If you want the argument later, you'll have to get back with us, okay? Title 31 United States Code, and we're going to quote it. Except as otherwise provided by law, all stocks, bonds, treasury notes, and other obligations of the United States government shall be exempt from state, municipal, and local authority. This exemption extends to every form of taxation that would require either the obligations or the interest thereon, or both be considered directly or indirectly in the computation of the tax. See Memphis Bank versus State of Tennessee et al. Garner. Notice this is Memphis Bank versus State of Tennessee et al. Garner. Everybody got that? That's recorded at volume 459, U.S., page 392. Okay, right here. Can you see that? Okay. Now, what this case is this is a Supreme Court case that says that Title 31 United States Code Section 742 is the supreme law of the land. And it does so on a diversity of tax arguments based on discriminatory franchise of bond holdings. But basically what the Supreme Court said was Title 31 Section 742 was the supreme law of the land. And recorded right in here is exactly what I just quoted to you. Right here, except as otherwise provided by law. Notice it says all stocks, bonds, treasury notes, and other obligations of the United States shall be exempt from state taxation by or under state or municipal or local authority. Now what does this mean? What are they talking about here? This exemption extends to every form of taxation. That would require that either the obligations or the interest thereon or both be considered directly or indirectly in the computation of the tax. This is a unique tax argument. See, when the states went off the Article 1, Section 10 gold and silver standard, you can't pay anyway because of Michigan Compiled Laws Act 21.153. You cannot tender anything other than gold or silver coin to an officer of the government without being a party to a felony. On top of that, how do they figure the taxes? Let's look at our property taxes. This is a big issue. A lot of people get involved with this property taxes. They're tired of being taxed right out of their home. This tax argument is specifically for you. They come to your house, they set a value on your house, they tell you that, your house is worth $100,000, so we're going to tax it at a 50% interest, which would be $50,000. That's a 50% amortization value. We'll figure your house is a $50,000 bracket area, and then we're going to go 7 points on that, 7%, or whatever the percentage is. Now, stop for a second here. How did they figure the value on your house? Well, they said $50,000. There is no dollars. What dollars? You ain't got no dollars. You got dollars? I ain't got no dollars. Dollars of what? Dollars of coffee beans? I don't think so. The bottom line is they talking Federal Reserve notes, and they're putting the commodity item at the reserve notes. Now, what did they just do? Except as otherwise provided by law. All stocks, bonds, treasury notes. What is a Federal Reserve note? It's a treasury note. And other obligations of the United States. What obligations? Title 12, Section 411 says the said notes shall be deemed to be obligations of the United States government. Whoops. Now wait a minute. Let's look at this again. Except as otherwise provided by law, all stocks, bonds, treasury notes, and other obligations of the United States shall be exempt from taxation by or under state or municipal or local authority. Does that mean they can't figure a tax by using obligations to the United States government? You're right. You're absolutely right. This exemption extends to every form of taxation that would require either the obligations or the interest thereon, or both be considered directly or indirectly in the computation of the tax. Now, what are they doing when they figure this 50% amortization of value, and then they add so many points percent on, and they attack that on, and then they say, well, you owe us this much? Aren't they using Federal Reserve notes indirectly? They are, aren't they? And they're forbidden from doing that. And the Supreme Court says this is the supreme law of the land. Well, guess what, folks? This case was originally brought in the matter of People v. Shepard out of Lansing. And after that case, they went in all the law books and they pulled out Title 31, Section 742. That's how scared they are of this title. And we went to Shepard Citations, and we noted that in Shepard Citations there was no note that says annulled, repealed, or otherwise transferred to some other law. There's a hole there, folks. It starts at Title 31, Section 734, and then there's a hole, and then it goes to 752. What happened here? They went in all the law books and pulled this argument out. Why do you think they did that? Because every state in the Union that went off the gold and silver standard under Article 1, Section 10 was locked out of taxing the citizenry in any capacity by the use of obligations of the United States government. That's the only thing you got in your hand, folks. So rather than play that game, they went in all the law books and pulled it out. Then they went in Shepard Citations, and instead of putting a note down there as to what happened, they just created a void. What is that evidence of? Fraud. Fraud. Does not fraud void the contract? Last time I checked, it did. Now, I want you to pay attention to this stuff and get locked in on this argument, and don't try this until you've at least practiced a little bit. But anybody that's getting jammed on their property taxes or any other taxes for the state, lock their heels, is all I got to say. Okay? Now, we're going to go into one last argument on income taxes. And I'm not advising you as your attorney. I'm telling you what I have found as a scholar. In the law books, I have found these arguments, and if you want to use them, that's your free choice. This is America. Last time I checked, you have a right under the Constitution. We've argued this before the Supreme Court, though, and it cannot be argued against. It's pretty strong. Bear with me a second here. My voice is going. Now, since the Constitution... Alright. Since the Constitution of the United States is the supreme law of the land, we got a unique argument here. It says in Article 1, Section 9, Paragraph 4, most clearly, no capitation or other direct tax shall be laid, unless by the enumeration or addition hereinbefore directed to be taken, and that's in Article 1, Section 2, Clause 2, which says income taxes and representation shall be